An overview of the eviction process. This video will provide a brief overview of the residential eviction process, legally referred to as an unlawful detainer. There are 7 steps. Step 1. Written notice to tenant. Step 2. Case is filed with the court. Step 3. Tenant is served. Step 4. Response may be filed. Step 5. Scenario 1. Tenant does not file an answer. Scenario 2. Tenant files an answer. Step 6. After the judge decides a case. Step 7. Post-judgment relief for tenants. Step 1. Written notice to tenant. A landlord must give the tenant written notice before starting an eviction case with the court. The type of notice provided will depend on the circumstances of each case. There are several types of common notices. A 3-day notice to pay or quit is used when a tenant is past due on their rent. If you are filing for an eviction based on non-payment of rent on or before June 30th, 2022, special rules may apply. Please visit the Self-Help Center for more information. A 3-day notice to perform a covenant or quit is used when the tenant has violated the terms of the rental agreement or lease, but the violations can be corrected. A 3-day notice to quit is used for serious violations of the rental agreement that cannot be corrected. Some examples include: the tenant has engaged in illegal activity, improperly sublet, or is causing a disturbance to others, or has caused damage to the property. A 30-day notice to terminate tenancy can be used for a tenant who has lived on premises for less than 1 year. A 60-day notice to terminate tenancy can be used for a tenant who has lived on the premises for more than 1 year and the property is exempt from the Tenant Protection Act of 2019. The Tenant Protection Act requires that if a tenant has lived in the rental property for at least 12 months, the landlord must have just cause to terminate the rental agreement. Just cause is a legally valid reason to evict, which can be a reason caused by the tenant's rental lease agreement violation. For example, when the landlord gives a 3-day notice to pay or quit, 3-day notice to perform a covenant or quit, or a 3-day notice to quit, or when the tenant has not violated any rental lease agreement. For example, when the landlord gives a 30-day notice to quit or a 60-day notice to quit. Once the landlord has decided which notice to give the tenant, the landlord must provide that notice in writing. There are 3 ways a notice can be given. To learn about the proper methods of service of notices, go to this link. Step 2. Case is filed with the court. If the tenant does not do what the notice says by the deadline, the landlord can start an eviction case with the court. The landlord would file the civil case cover sheet, CM 010, summons Sum 130, and complaint, UD 100. There is a fee to file. If the landlord cannot afford the fee, they can apply for the fees to be waived by submitting a fee waiver application or forms request to waive court fees, FW 001, and order on court fee waiver, FW 003. For the current fee schedule, go to this link. Visit the Self-Help Center at Central Justice Center to obtain the forms needed to file an eviction case. You can also request forms online by visiting the court's website at occourts.org, clicking on Self-Help, then clicking on the blue box. Click here to contact Self-Help Services. Step 3. Tenant served. Who can serve? The landlord must have a copy of the filed court papers delivered, served, to the tenant. The landlord cannot serve the tenant. After the tenant is served, the tenant will have to file a written response with the court if they are to be heard by the court. Note: there is a deadline to file a response. A third-party adult, a process server, or even the sheriff may serve a tenant in one of the following manners. Personal service. Documents are given to the tenant by hand. Substitute service. Documents are given to another adult at the tenant's residence or place of business, and a copy is mailed via first-class mail to the tenant. Or posting and mailing. If a court order is obtained, documents can be posted in a conspicuous place at the residence, and a copy is mailed via certified mail. How much time a tenant has to file a written response depends on how they were served. If the tenant was served in person, they will have 5 business days to respond, not counting Saturdays, Sundays, or court holidays. If the tenant was served by substituted service or post and mail, they will have 15 days after the date the server mailed the court papers to file a response. The date of mailing is the postmark date. Day 1 is the day after the server mailed the summons and complaint to the tenant. For the first 10 of the 15 days, count regular calendar days, every day, including weekends and holidays. The 10th day is the day your tenant is considered served. Then count 5 court days. For these 5 court days, do not count Saturdays, Sundays, or court holidays. Step 4. Response filed. There are different ways to respond. However, most tenants respond by filing the answer Unlawful Detainer, Form UD 105. The answer sets out the defendant's legal reasons why they should not be evicted, known as affirmative defenses. If you will need an interpreter on the day of trial, make sure to also file the request for interpreter, civil, Form INT 300. You can find this form online by visiting the court's website at occourts.org, clicking on Forms and Filing, then Forms, Self-Help Form Packets, then Interpreter. Visit the Self-Help Center if you need these forms. Step 5. Scenario 1. Tenant does not file an answer. The landlord can proceed in the case and obtain a judgment for eviction against the defendant. The landlord will request a default judgment to be entered and writ to be issued. The writ will authorize the sheriff to post a 5-day notice to vacate on the property and then perform the eviction on the posted date. This means that the tenant will be locked out if they have not vacated prior to the sheriff coming to undertake the lockout. Step 5. Scenario 2. Tenant files an answer. If an answer was filed by the tenant with the court, the landlord will then have to request a trial date. The day of the trial, the parties may be offered court mediation. If the parties come to an agreement, they will be asked to submit a written stipulation. If the parties cannot come to an agreement, the judge will determine the outcome of their case at trial. Both parties should come to court prepared for trial. To ensure the judge understands the situation, both parties should gather any documentation or evidence that will support their case. They can even bring witnesses. It is a must that both parties dress for court. It is always a good idea to make a good impression with the judge and to show respect for the process. The judge will set the tone for the hearing and address each party as needed. Each party will know when it is their turn to speak. No one should interrupt the judge or the opposing party when they are speaking, but instead should wait their turn. It is also wise to use concise explanations, descriptions, and statements when speaking. Parties should always address the judge with "Your Honor." Once both parties have had the chance to present their case, the judge will make a decision. Step 6. After the judge decides a case. If the judge rules in favor of the landlord will submit a judgment to the court. The writ will be issued, which will authorize the sheriff to post a 5-day notice to vacate on the property and then perform the eviction on the posted date. This means that the tenant will be locked out if they have not vacated prior to the sheriff coming to undertake the lockout. If the judge ruled in favor of the tenant will not have to move out. Step 7. Post-judgment relief for tenants. Even after a judgment has been entered against the tenant, whether at trial or by default, post-judgment relief may still be available for the tenant. For more information, please contact Self-Help Services. For additional assistance, contact Self-Help Services at the following link.